Big news coming in from the Supreme Court that has said that they will be reopening a debate on Section 377. Very interesting bit of news coming in right now. This after Ravi Shankar Prasad in the winter session had said that there is consensus after a detailed debate is needed for any decision on Section 377. Supreme Court now reopening that debate on this particular section. Anusha Soni joins us for more. Anusha, over to you. First, give us the details.
So this is a fresh petition, public interest litigation, which has come from some social activists who have challenged the earlier judgment of the Supreme Court. Now, we must remember that after the privacy judgment, the 9-judge bench had already made certain observations about this judgment pertaining to Section 377 and said that, in fact, it's a judgment in bad taste and it has hurt the preferences of a lot of individuals. The curative petition in the main and the parent case was already being heard in an open court. So this case had already, got a fresh lease of life about 2 years ago. With the privacy judgment, it got another boost, and now there's another fresh PIL which has been filed. So what is expected is that the NAS Foundation case, whenever it is heard in the Supreme Court, it will be heard along with all the petitions together. So this is, Avantika, a momentum building up as far as the judiciary is concerned, because the court will have to overturn its own judgment.
Exactly.
Which is not very long ago.
Absolutely. Absolutely. You're right. And that was not very long ago, because Section 377 of the IPC, it criminalizes homosexuality, isn't it, Anusha? So what does the Supreme Court mean that they are open to having a debate? Because this is something that was also, mentioned by the law minister during the winter session, that the government was also open to a debate on this particular section.
So Section 377, by certain interpretations, does criminalize homosexuality. So what the Supreme Court did, I think back in 2012 when the judgment had come, is that it refused to turn down or strike down that section. It said we'll not interfere. If the Parliament wants to do it, they can go ahead and do it. Now with the court hearing this matter all over again, it is now open to the judiciary to step in and strike down this section.
No, but then why did the Supreme Court repeatedly say earlier on that it is up to the Parliament to take any decision on this particular law?
So, Avantika, I could just say it in as many words, is that different judges have different interpretations of law. Law often does not reach a very objective interpretation in many contentious matters like 377. A bench of a certain, led by a certain judge may think that this is a matter for the Parliament. Others may like to interfere. It is also about, preferences. Section 377 is such a contentious issue in this country. But you know what? The writing on the wall right now, after the 9-judge privacy judgment, is very clear that the privacy of individuals, the sexual preferences of individuals are of utmost importance. And they are something which is very, personal to people, and the state cannot dictate that.
But it's interesting. Yes, Anusha, but it's interesting you say that, because the 2012 judgment of the Delhi High Court had struck down IPC Section 377, and that's when the Supreme Court kept it aside, saying it is for the legislature to look into this. And now you have the judiciary willing to reopen the debate on Section 377.
The judgment of Justice A.P. Shah from the Delhi High Court, a lot of legal scholars say and experts say, was a very progressive judgment. When it came to the Supreme Court, it has been severely criticized, even by the 9-judge bench of the Supreme Court, for using words like so-called LGBT community, so-called sexual preferences. It is argued that it is derogatory in many ways and insensitive in many ways and hurts the sentiments of a certain section of the community. So clearly, that judgment has been widely criticized. The way Supreme Court, set aside the order of the Delhi High Court, the sort of reasons it gave. And we must remember that even the judgments of the Supreme Court are open to scrutiny and a fair debate in this country. And it's very interesting, and some may see very heartening as a progressive move coming in, that not a judgment delivered in less than, 5 years ago, 6 years ago. And the Supreme Court is now ready to look at it. So clearly this is a big boost for the LGBT community for their cause.
But I'm just reading this, Anusha. Why then did the 9-judge Constitution bench observe, and I quote, that Section 377, by criminalizing homosexuality, poses a grave danger to the unhindered fulfillment of one's sexual orientation as an element of privacy and dignity? I mean, isn't that going against to what the Supreme Court had said by upholding Section 377 of the Indian Penal Code?
Absolutely, absolutely, Avantika. That judgment, the 9-judge bench judgment, it did not mince any words. It very openly criticized the 2012 judgment and said that, the judgment is wrong on so many points. And Justice Chandrachud there, using some very strong words and saying that sexual preferences are someone's own choice and you can't really go ahead and dictate these things. As we've been repeatedly pointing, and I'm repeatedly saying, the privacy judgment is one judgment which is about the rights of the citizens in the modern democracy.
Right. Anusha, if I may just interrupt you there, just excuse me for doing so, but we have Akai, who is also an LGBT activist, joining us right now on the broadcast. Thank you so much for speaking to us. Your initial reaction on this big news that has just come about with the Apex Court willing to reopen the debate on homosexuality, on Section 377 that criminalizes homosexuality, and willing to hear LGBT activists and review the section altogether?
I think it's a milestone day.
Okay.
It's a warm welcoming. And it is not only about homosexuality, it is about the human sexuality. And I want to use the slogan called "Judge not support gender identity, judge not support sexual diversity." I think Supreme Court of India, when it rejected on the Delhi High Court of 2009, and it said in 2013 on 11/12/13 said Delhi High Court judgment is unconstitutional, and the amount of social exclusion, the amount of violence, the amount of social stigma was so much in high. And the Parliament also has also rejected the human sexuality issue. I think that is quite saddening. And I think the trust on the judiciary of the country is very much high, and we still keep that, in that way. I think we warmly welcome this review, on Section 377 should definitely see a vast amount of global politics of sexuality. And to speak about the United Nations sexuality issue, I think India cannot go against, the human sexuality agenda. If you're gone there, I think India is again back to 16th century. That's what I wanted to say. I think now the current government, all the political leaders and parties now should come together to support the rights of sexuality, rather than you judging people's identity and sexuality.
And it's interesting you say that, because this is just not about homosexuality. It's about an individual's right to privacy, which is intrinsic really to life and liberty. It's about fundamental rights of personal liberty, equality, and gender discrimination as well. There's just so much to Section 377.
Yeah.
So are you hopeful? Are you hopeful now with the Supreme Court willing to open the debate? Are you hopeful now?
I'm very hopeful.
Okay.
I'm very trust again, on our Indian judiciary, and our largest constitution talks about the politics of secularism and socialism, and we are not practicing the voice of communalism. I think yes, I'm here to speak about socialism and secularism, and still we have a hope and hopes of trust on our Indian judiciary.
All right. Thank you so much for speaking to us, Akai. We also have our legal correspondent, Anusha Soni, who's just putting things in perspective. Anusha, what does this entail? Because Article 377 is an important one. It is something that, has been talked on for years together. But by reopening the debate, by going back into this case, what does this mean?
So, Avantika, let me just put things in context here. It is not fair to say that the case was not reopened earlier. About 2 years ago, when Justice Thakur was the Chief Justice of India, the curative petition of the NAS Foundation was heard in an open court. Justice Thakur and the centre also was of the opinion that this case needs to be heard afresh, and a fresh debate is required on this matter, especially when the government had changed. So the Supreme Court was already ready to hear this matter afresh. It was only a matter of time. These 5 individuals, these are social workers and activists, had filed this petition back in 2016, just after the Supreme Court, was of the opinion that, there's something that fresh needs to be done. Now, with this fresh public interest litigation coming into being, the NAS Foundation case also gets some more, lease of life and some more backing, for the simple reason that it can bring fresh arguments into the matter. But it would be worth noting whether this curative and these petitions will be heard together or not. Because in this case, NAS Foundation is the main petitioner.
Okay.
Their plea needs to be heard and to be settled. So as I was pointing out, this needs to be seen in the proper context, which is that there is a momentum of building up at the top corridors of the judiciary to relook at its own earlier decision, which refused to decriminalize homosexuality in the country.
Okay, but just correct me if I'm wrong here, because there's just so much that has happened on Section 377. Didn't the Chief Justice of India, then T.S. Thakur, also mention that all of the curative petitions that are expected to be heard by the Supreme Court that you were mentioning needs to be referred to a 5-judge constitution bench? Then do you foresee that happening? Do you think that will have to take place for this entire debate to be reopened, to be looked into all over again?
Well, it is certainly an option which is available before the Supreme Court. It was the 2-judge bench earlier when the order had come. So it is completely open for the Supreme Court to refer it to a 3-judge bench or to a 5-judge bench. That is a matter we'll have to wait and watch. That is completely up to the Chief Justice of India. Of course, if this matter goes to a 5-judge bench with the privacy judgment in mind, this will have, this will be a very welcome step for the rights of the LGBT community, because a 5-judge bench judgment will have far-reaching implications. It will settle the law once and for all. 3-judge or a 5-judge, it is now going to a larger bench. That is settled.
And, so why don't you just tell us, Anusha, how did this matter come up all over again? What exactly did the Supreme Court say? Because the fight against Section 377 received a major boost when the 9-judge bench of the Supreme Court upheld the right to privacy as a fundamental right intrinsic to life and liberty.
That's right. So let me just put it in context. Right after the Narendra Modi government came into power, there was a fresh lease of life. The curative petition of the NAS Foundation was heard in an open court. Usually curative petitions are not heard in an open court. They are in chambers matter, and there's hardly any change of heart or a decision that happens. But the bench led by Justice T.S. Thakur then decided that this matter needs to be heard in open court. After that, the centre, then represented by Attorney General Mukul Rohatgi, was also of the opinion that yes, we do need to bring a fresh debate on this entire issue. There should be a fresh argument that should happen. A lot of clergymen from the Christian, from the Muslim, from the Hindu community had come forward and said that, the judgment is just fine. There is no need of any interference from the court. Interestingly, I've been repeatedly asking the petitioners, the NAS Foundation people, and also Mr. Anand Grover, who's representing them, that when are you actually going to push for this matter? And his answer has been that, there is increasingly a consensus building up and we're just waiting for the right time to come in. Now, with this fresh writ petition also coming in, the Supreme Court expressing a certain view, we'll have to wait and watch when this matter is listed. A momentum building up, a consensus building up, and it's heartening to see that the Supreme Court is looking at much criticized judgment. It has been openly criticized in the 9-judge bench judgment, and also legal scholars across the spectrum have criticized it for its language and its approach.
And there's been a lot of criticism coming about for this law that has been termed, archaic, an old school law that needs to be abolished from activists across various sectors, right? About how the need, how the time has now come to decriminalize homosexuality, especially when it is between two consenting adults of different sexual orientation. There's just been so much talk about this issue as well in the last, so many years.
That's right, Avantika. In issues like homosexuality, the most interesting aspect is that such cases are the meeting focal points of law and morality. Now, law might be static, objective, but morality differs from judge to judge, from benches to benches, and different people may have different interpretations, and that's what has happened in the case of homosexuality. While Justice A.P. Shah, one of the best-known judges of this country, went ahead, decriminalized, he struck down that section.
Yes.
The Supreme Court reinstated it. A lot of people who support 377 say that 377 is just not about homosexuality. It's also about certain offences like sodomy, also some sorts of behavior that happen, especially in the case of, there is no marital rape in this country. They have not criminalized it. So in most of the cases, wives usually use Section 377 to point out any sort of sexual behavior which was unacceptable. So the supporters of 377 say that it is beyond homosexuality. But one has to look at the trust of a section, whether it's doing something which takes away the right of a certain community, and that's what the argument will be in the Supreme Court.
Very interesting. And there's so much that has been going on in this case since 2012, right? And then you had 2014, and then you have the Supreme Court once again ripping apart its own 2014 ruling on Section 377. But what I want to understand from you is, Anusha, that even the Supreme Court has been going back and forth on this matter. Why is it that they wanted the legislature or the parliament to decide on this matter and not really wanting the judiciary to get involved or interfere?
Well, Avantika, the answer is very simple. The present government could have just brought a bill and, outlawed triple talaq. In the same way, the present government could just bring a bill and, make sure that homosexuality is not criminalized in India. The problem is that with politically contentious issues, no one wants to get into a spot and everyone wants to take a safer route. Often judiciary becomes a platform where people try to bring in these contentious issues so that they can be settled objectively. That is not always the case. Sometimes there are political problems which overtake a certain debate, which does seem to happen in the case of homosexuality, and that indeed was one of the case. Different bench had a different opinion. At the same time, if you look at courts across the world, Avantika, very importantly, homosexuality across the world is a very contentious topic, even in the even in countries like America.
That's true.
And it's the courts. It's the courts which have stepped in. It's the courts which have said that homosexuality is not a criminal offence, and that's what Supreme Court could not do in 2014. Hopefully, with this debate reopening, let's see how this pans out.
Absolutely. Anusha, thanks so much for joining us. But I'm going to come back to you for this big story. I'll just come back to you with the Supreme Court deciding to revisit the verdict criminalizing gay sex, deciding to once again reopen the debate on Section 377. A big story that we are tracking. Stay tuned. India Today will be back in just a bit.
Thanks for watching the video. For more such news and updates, please like, share and subscribe to India Today. Also check out our other great videos from our channel. We know you would love to.